Morning.
Good morning.
Good morning.
We're here on the case of Bernier Jackson versus State, 20-899. I'm Judge Evander. The other members of the panel are Judge Edwards and Judge Harris. You will each have 20 minutes aside for oral argument. If the appellant wishes to reserve some time for rebuttal, just let me know how much time you wish to reserve and I'll try to help you in that regard, but there is a clock on the screen to help you as well. Also, I do want to remind you that these oral arguments are being live streamed, so the public does have an opportunity to observe them. With that, Mr. Chase, if you wish to proceed.
Yes, Your Honor. I'd like to reserve 5 minutes for rebuttal, if I could. I'm here on behalf of Appellant Bernier Jackson. Mr. Jackson was convicted of robbery with a weapon following a jury trial and is currently serving a life sentence. The issue before this court is simply whether his trial counsel performed ineffectively by failing to advise him that acceptance of a state-offered plea agreement of 8 years imprisonment, 8 years imprisonment was in his best interest. Case law is clear that defense counsel does in fact have a duty to advise a client what plea he should be entering. Here there is no dispute.
Let me ask you about that. Does the defense counsel have a duty to say, I advise you, you should accept this plea, or I advise you, you should reject this plea? Or is the duty to give the defendant all the information he or she needs to make an informed decision?
He has an affirmative duty to actually advise, either accept or reject this plea offer. And I think that all goes back to the Supreme Court case, that Van Multi case. And there's a plethora of circuit court decisions, some of which I've cited in my brief out of the 11th Circuit and also the 2nd Circuit that also agree with that proposition. I recognize that the state filed supplemental authority basically saying that there are some instances where that's not true. But number one, obviously the 2nd Circuit can't overrule a Supreme Court holding. And number two, the circumstances of that case were markedly different. As that court pointed out, you had a situation there where there was only a 6-month difference between the plea offer, and it wasn't necessarily clear whether it was in his best interest. Here, it's very clear that it's in his best interest to accept this plea, and I think that the case law bears out that especially when it's very clear, there's no question about it, that there's an affirmative duty on the behalf of the defense counsel to make that advice or to give that advice to enter that plea.
How do we weigh Mr. Jackson's seemed like adamant refusal to plead to anything that included robbery, no matter what amount of term he was going to get?
It really doesn't come into play here because that doesn't forgive the duty of defense counsel to still give him that advice, to still tell him emphatically, look, you need to go into this with eyes wide open, realizing and knowing that that's a terrible decision and you shouldn't be doing that. This isn't in your best interest. And if you look at the dissent in Waite, which is another case that was cited by the state, that's exactly what they're saying there. I realize it's dissent, but its logic is sound. He needs to be going to this with eyes wide open.
Wasn't there, maybe I'm just not remembering this right, wasn't there an earlier offer that was like a range of 8 to 10, and Mr. Jackson said, I don't care what the offer is, I'm not pleading if it includes robbery?
There was an earlier offer that, quite frankly, it's not really clear what the terms of that specific offer were, but he rejected it because at that point, there hadn't been a full investigation of the case. So he's basically said, look, no matter what, I don't want to take this until there's an investigation done. And then ultimately, push comes to shove, the offer on the table is 8 years, and he rejects that, but he's never afforded that advice that, hey, look, I know you don't want to go to trial. I know that you're adamant you didn't commit this robbery, but here's the reality of your situation. If you take this thing to trial, it's going to be game over and you're going to get a life sentence.
If the defendant was acquitted of possession of a firearm by a convicted felon, if he had been convicted of grand theft only, what would the maximum sentence be, and do you know what he would have scored?
To be perfectly honest, I don't have the answer to that. To be perfectly honest with you, okay. If memory serves, it would be a 5 years. Prison would be, I believe, would be a 3rd-degree felony, but I'm not 100% sure on that. To be honest with you. But regardless, there's no forgiving the defense counsel's failure to give this advice. I understand again that Mr. Jackson had made it clear that he didn't want to accept a plea, but that doesn't relieve him of his responsibility of telling him that, look, regardless of your wishes here, this is in fact what's in your best interest. And he needed to hear that to make an informed decision as to whether or not to accept or reject that.
Didn't Attorney Graves say that he was certain he had gone over the strengths and weaknesses of the case with him?
Yeah, he did go over the strengths and weaknesses of the case, but that still doesn't tell the client that he's in a situation where he needs to accept a plea. Just as kind of an example, taking it out of the context of the court here, if you had cancer and a doctor told you, here's the strengths and weaknesses of chemotherapy versus radiation, wouldn't you still want to know what the doctor's advice was as to what you should do? And that's exactly what we have here. He still needs to be informed of, from a professional standpoint, what's in his best interest. He's not equipped to make that decision on his own.
But if the patient says, I don't care what you recommend, I don't want chemo.
Yeah, that's certainly his decision to make, but he still.
And that's kind of what Dr. Jackson did here. I don't care what the offer is. I don't want robbery.
But he didn't receive the advice of counsel that regardless of what you want, it's still in your best interest. And he needs to know that it is in his best interest.
What do we do with the fact that he has 8 prior felony convictions? I understand on the one hand, he resolved them all by plea, which might lead to certainly supports your argument that if only he had been told to take the plea, he definitely would have, because he always did before. But again, you're not looking at somebody who's a babe in the woods, who's never been in the system before.
Well, I understand that, but again, like you just said, it does support the proposition that he follows the advice of counsel and that if he had received proper advice here. But then more important than that, because really that goes to the prejudice prong of this, and you're not really looking at what Mr. Jackson himself would have done. You're looking at what a rational defendant would have done with proper advice.
Let me go back to your cancer analogy, because I think that can be helpful. If the doctor had said you got a 30% chance of beating this if you do radiation treatment, you got a 50% chance if you do chemo, but it's much more painful. Your life will be just utter misery for 6 months, which wouldn't happen with radiation. And the patient says, well, what do you think? And the doctor says, well, that's up to you. I've given you that information. Would that be appropriate for the doctor? I mean, because it seems to me in this case, there's some suggestion that the defendant said state has a very strong case on the grand theft and not so strong on the robbery. You got a decent chance of beating the robbery.
No, I don't think
the robbery you can get up to life, but grand theft, 5 years max. Can the defense counsel leave that choice to the client if he advises the client of those possibilities?
Well, the Supreme Court says no, that he has to give him that advice. And if you think about it, it also makes sense, because if we're saying that counsel can't be expected to, look at the strengths and weaknesses of a case and reach an informed opinion as to what plea should be entered, how can we possibly expect a layperson of the law to look at the strengths and weaknesses as they've been laid out and then come to an intelligent, rational decision as to what plea should be entered? So if counsel isn't expected to do that, it's hard to see how we can expect the defendant to do that. At the end of the day, he needs that informed professional advice from the attorney, and it's that attorney's duty to offer that, notwithstanding the fact that the client might indicate that he has no desire to accept the plea. He still needs to do that. He still needs to be informed of that. There's not really a reason or excuse for him to forego giving that advice. So no matter which way you slice it, I mean, there's not really a sound reason why a defense attorney would fail to offer that advice. In the situation like Purdy, which was the case that counsel submitted, maybe there's an argument to be made that, this is a really close call, kind of like what you were saying with the cancer analogy with the 50 versus 30, and I'm not really sure. Maybe in a circumstance like that, counsel could reasonably fail to give advice because it's kind of up in the air. It's anybody's guess. But we don't have that situation here. We have a situation where it's very clear that this was in his best interest. He's looking at 8 years imprisonment or
let me ask you this. Your position that there's a duty to advise counsel to accept or reject as a reasonable person, how does that take into account the individual who He says, if I go to prison, if I'm convicted, my life is over, regardless of whether it's 1 year, 5 years, or life. And my only hope to have a decent life is to go to trial and get acquitted. I mean, how does your theory account for that?
Yeah,
That
then the defense attorney needs to weigh that into his opinion. I mean, at the end of the day, we're not necessarily saying right or wrong, or that there's a right or wrong way for a defense attorney to advise a client in terms of what the opinion itself is. What we're saying is that he has to give that opinion, and that opinion has to be reasonable. And in certain circumstances, like you just laid out, if that were the facts of this case, it may have been reasonable for him to say, look, you should take this thing to trial. But under the facts that we have here, there's not a reasonable case to be made for an attorney to say anything other than, look, Mr. Jackson, you need to accept this. Otherwise, you are going to die in prison. And you need to be aware of that.
Here, the defendant was aware of all the facts that you laid out in your brief in terms of why he had such a rough case. It's not like there was some subtlety, some intricacy that was hard to grasp. He was adamant. He wanted 51 weeks in jail, period. I don't want to hear about anything else. And yet the attorney still, according to his notes, discussed it with him and gave him the strengths and weaknesses, and apparently told him the state wouldn't have much trouble convicting you on some of this stuff. I mean, it's, where's the mystery here? What else did he need to be told other than take it? And at that point, doesn't Purdy say, you got to walk a fine line here between coercing and advising?
Well, first of all, I don't think that he ever actually told him that he would have no problem convicting him. I think that's a misquote from the state's answer brief, quite frankly. But at any rate, he still, at the end of the day, has the duty, no matter what, to tell the client, this is in your best interest, point blank. And the other reason for that, again, is that, he's leaving the window open to Mr. Jackson of some kind of hope by just going over the strengths and weaknesses. And it's just natural for a defendant who's looking at, 8 years, why would I take that when I can go to trial and at least I have some semblance of a chance of avoiding prison altogether? And counsel needs to make that very clear to him that, look, yeah, there is a chance, but it's not realistic. You need to be realistic here. And it's
I don't think there's any testimony that defense counsel held out a hope for a total acquittal. The defendant admitted he stole the money. I mean, there's no hope for a total acquittal.
Well, right, but he also tells him that he's got a strong case as to the charge of robbery with a firearm. And then where does that leave him? There's no testimony from the defense counsel as to where that leaves Mr. Jackson. So Mr. Jackson's in a situation where he's being told that he's got a great case against the number one charge against him. But he's not being told to the legal consequences of that. And so if you win this on the robbery charge, the robbery with a firearm charge, where does that leave you? What position are you in with respect to the 8-year plea offer? Are you still in a better position? Are you in a worse position? Where are you? And we don't have that advice. We just have advice that says you've got a great case against the mandatory life sentence for robbery of a firearm, and that's it. And regardless, like I said, at the end of the day, there's no getting around the fact that the Supreme Court says you have to give this advice. The Supreme Court doesn't say, there's certain circumstances where maybe you don't need to do it, or under these circumstances, you don't have to do it. It's cut and dry. It's point blank. It says you have to give this advice. And because of that, he performed officially by not following the Supreme Court mandate. And you also have the Florida rules that basically lay that out as well under 3.171, where it talks about needing to advise your client of all pertinent materials, issues that are material to the decision to plea and the likely consequences thereof. And if you're laying out the likely consequences, you're basically telling him, this is
that rule certainly stops short of saying you must say take it or leave it.
It does, but again, it goes back to the Supreme Court. They did not stop short. And so we're left in a situation, again, the Supreme Court says that advice needs to be offered. And again, I think that, when you think about it, it does need to be offered because he's the professional. He's the one that knows what's in his best interest, and he should be offering that advice. And then it's up to the defendant at that point to take it or leave it. So there's still.
Does there have to be some evidence that your client would have taken it or would likely have taken it? I mean, if you get back to 8 prior convictions resulting from 8 plea agreements, you made a statement earlier that that's evidence that he would have followed counsel's advice. Well, I don't see that necessarily. Counsel could have advised him in each of those 8 cases reject the plea. Let's go to
Right.
trial.
Right. Well, and that goes back to what the objective versus subjective standard. If it was subjective, yeah, we'd have, might be an issue here as to, whether he would have really taken this, who knows. But objectively speaking, a rational defendant, given advice from his counsel that says, look, this is what's in your best interest, could have reasonably, in this case, accepted the offer. And that's all the Supreme Court requires for the prejudice prong. In addition to that, even under a subjective standard, you've got a situation where he has a history of listening to counsel's advice. You've got a drastic difference between a life sentence at trial and 8-year plea agreement. He could have reasonably.
How do we know he has a history of listening to counsel's advice? That's what I'm getting at. How do you assume that from the fact that he pled 8 times?
Because he pled
and against counsel's advice.
He could because he did actually plead 8 times. I mean that the proposition stands for itself.
What Judge Harris is saying, his lawyer 8 times could have said you should go to trial on this, and he ignored that advice.
We just
We
don't
don't
know.
know.
Well, again, that's fair. You don't know, but at the end of the day, it's still an objective standard, and even under a subjective standard, it's still just a reasonable probability.
How does a trial judge apply an objective standard to somebody who, it's hard enough in a tort case trying to figure out what the reasonable man is. How do you figure out an objective standard? How do you factor in 8 prior convictions? How do you factor in the guy definitely stole the money and admits to, and all the rest of that? I mean, how in the world is a trial judge supposed to do that?
Because you look at it from the standard of what a rational person would do. That's the
But
objective.
no rational person would steal and get convicted. That's what I'm saying. How in the world are you supposed to do that?
You're 4 minutes.
If you want to save your time for rebuttal, that's
I'll
fine.
save my time, Your Honor. Thank you.
All right, thank you. All right, for the state.
Good morning. As far as the Supreme Court case, I'd just like to point out that, as is often stated, death is different. In these cases, the appellant testified he didn't accept the plea offer because he wasn't told to. As the court has pointed out, Rule 3.171 does not explicitly require a defense counsel to advise a client in that regard. It doesn't, by implication, say that it should. In fact, I think the important thing to remember is, as was pointed out by the Purdy Court in Strickland, the United States Supreme Court said that defense counsel has to be given a wide range of reasonableness when it comes to advising a client, because, as Your Honor said, it's the defense counsel who has to walk that fine line between giving adequate advice and coercing a plea. And because Purdy was similar to our case in the sense that the Second Circuit Court upheld that trial counsel's decision not to explicitly and specifically advise Mr. Purdy what to do based on his steadfast protestations of innocence. And that's exactly what trial counsel testified to at the evidentiary hearing here.
But you have to agree, don't you, with appellant's counsel's statement? The defendant in Purdy was a sophisticated businessman, and ultimately the court in Purdy says counsel doesn't have to, under all circumstances, give the explicit advice to accept or deny or accept or reject the plea, but which means that under certain circumstances, counsel would have that obligation, doesn't it? I mean, if you
Well,
if you look at the
I
case
think
that way.
I think it is that part of that wide range of reasonableness that has to be given as far as the deficiency prong under Strickland. As Your Honor stated, if it's a complicated case involving experts and expert testimony and significant scientific analysis, for example, that might be more prone or more receptive to the idea of more specific advice on what to do with respect to a plea offer or not. Taking plea offer or not. But when it comes to this, I mean, the only real disparity in the evidence in this particular case was whether there was in fact a firearm involved. Trial counsel testified that the victim had testified both in deposition and later at trial that while the appellant in this case allegedly pulled up his shirt and kind of displayed the firearm after he took the money, and I think he said he even withdrew it a little bit from its waistband. He didn't actually pull it out and point it. And the victim testified, I didn't know if it was a gun or if it was a real gun or not. And so under these circumstances, he trial counsel testified at the evidentiary hearing that he thought that component, that part of the state's case was weak, but that the rest of the case was very strong and that the state would have no difficulty in obtaining a conviction on a robbery with a weapon charge. And in fact, that's exactly what was borne out at trial. The jury, in fact, wasn't convinced with respect to the firearm itself, and instead convicted him of robbery with a firearm and acquitted him on the carrying concealed firearm and found him guilty as well as the grand theft. I think that also goes back to the Morales case, which just came out from the first DCA back in December of last year, after the briefing schedule was completed here, where they said that even where trial counsel testifies in a post-conviction proceeding, that they have no specific recollection of I did this or I did that in this particular case. My standard practice is to X, Y, and Z. And in this particular case, trial counsel Graves testified that his standard practice was to review discovery with his client, to go over the strengths and weaknesses, and basically let his client know if he had his words an uphill battle or whether he had, again, his words, a decent case. And in this particular case, based on the testimony that's before the court and the record, it was very clear that the state had plenty of evidence to convict the appellant of robbery with a weapon, as opposed to robbery with a firearm. But other than that, the state's case was strong. The whole case, Your Honor, comes down to whether the trial court's credibility determinations are supported by competent, substantial evidence. Because if they are, they're deserving of deference in this court. And here, based on the fact that not only were there 8 prior felony convictions, making the appellant intimately familiar with the plea process, counsel's testimony, both under Morales and simply the fact that under, I believe it was Alcorn and in Cassidy, in prior decision of this court, that said, because the trial court is sitting as finder of fact in a post-conviction proceeding, that just as a jury is in a jury trial, he or she is free to believe or disbelieve all or any part of a lay witness's testimony. So even if in fact it was uncontroverted that when the appellant testified that I didn't get advice on whether I should or whether I shouldn't, those findings of credibility by the trial court in this case are deserving of that deference because of the competent, substantial evidence. And that simply goes back to the wide range of reasonableness and the fact that Mr. Graves had to walk that fine line between giving adequate advice and coercing a plea. Are there any further questions?
Okay, thank you. Mr. Chase, rebuttal?
Still muted, Mr. Chase.
Sorry about that. With respect to the deference issue, that really doesn't come into play in this case for a couple of different reasons. Number one, there still has to be a finding of that the witness's credibility wasn't credible, and there's no finding here. All you have is the trial court saying that Mr. Jackson isn't as credible as his trial counsel, but they're not saying that Mr. Jackson wasn't, in fact, incredible or not credible with his testimony. So you get a situation where if their testimony conflicts, certainly the trial court found that trial counsel's testimony wins the day. But since there wasn't a finding that he wasn't generally not credible, if there's uncontroverted testimony, there's no basis for rejecting it. And there's not competent, substantial evidence in the record for rejecting his credibility or finding the testimony to be credible. I would also point out that with respect to the legal findings in this case, while deference is required to factual findings, it's still de novo review with respect to the ultimate legal conclusion. And we don't actually have any kind of findings of fact as to what advice was actually given. So even if you accept, or even if you take the position that he could reject Mr. Jackson's testimony and you wipe that completely from the record, you still don't have any kind of competent substantial evidence showing that he was actually properly advised. And the court's ruling is ultimately just that the advice that was given was appropriate. That is a legal finding that's not entitled to deference. You as the reviewing court can review that de novo and reach your own conclusion as to whether or not the advice in fact was appropriate. So ultimately, number one, there has to be some basis in the record for rejecting the testimony, and there's none given here. And number two, even if you do reject that testimony, it's still on this record clear that appropriate advice was not given and that he's entitled to relief. I would also touch on, the state brought up the Morales case. The difference with that is that in this case, we don't have testimony from counsel that says that his standard practice is to give advice as to whether or not a plea should be entered or what's in his best interest. So it's really in opposite. Morales doesn't really cover the situation here. And I would also point out that the state basically says that, look, it should have been obvious to Mr. Jackson that this plea was in his best interest because the facts were such that he was so guilty. How could he have rationally made this decision to go to trial? And I agree with that. And that goes to the greater issue here is if it's so clear, which it is, then why is counsel not giving that advice? Why is counsel not telling him this is in his best interest? And there's been no reasonable explanation for why he should be relieved of that duty or reasonable explanation as to why he wouldn't give him that advice. And the Supreme Court says that at the end of the day, he's required to give that professional advice, and the defendant is entitled to hear that so he can factor that into his decision for whatever it may be worth. The defendant is obviously welcome to reject that advice, but he at least needs to be offered the advice and have the opportunity to consider it before he makes that ultimate plea decision. And for those reasons, we think that the record clearly shows that there was a deficient performance here because there is no evidence, no testimony whatsoever that there was any advice given that he should accept this plea, despite the fact that it's clear to anybody that objectively looks at this that was in fact in his best interest and he should have been notified of that. So with that, we would submit that he was deprived of his right to the effective assistance of counsel, and his plea judgment and sentence should be vacated. Thank you.
Well, thank you both for your arguments.